Hello and good afternoon, and welcome to the second panel of today's SLAPP conference, where we're going to be hearing directly from journalists and lawyers from around the world who have been subject to SLAPP litigation. My name is Sarah Clarke, and I lead the Europe and Central Asia team for Article 19, which is the Global Freedom of Expression Organisation. And we've been working in a very focused way, along with our colleagues on the previous panel, on the issue of SLAPPs in Europe and globally. To start with maybe a little bit of our own research before we go to the journalists and lawyers from around the world. We've been conducting a lot of research into the phenomenon of SLAPPs against journalists across the EU, candidate countries, and of course the UK. And we're going to be publishing some of that research in the months ahead, where we've looked at hundreds of cases of SLAPPs against journalists in the region. And I suppose some of the points that were really teased out in the first panel, are the phenomenon that we see, the trends that we see in these cases. Primarily the severe power imbalance between the journalists and the plaintiffs. We heard a lot about the resources that a lot of the plaintiffs have when they're taking these cases. But some of the other issues that we've found in this research are actually just how difficult it can be for journalists and other victims of SLAPPs to even find lawyers who are prepared to fight the cases. In many countries, these cases are taken by businessmen and oligarchs and politicians, many of whom are often the same people in certain countries. And it's impossible for journalists in those types of contexts to even find lawyers who are prepared to defend them. We've also seen just how serious it is for media outlets to even have the amount that it costs to defend these cases on their balance books. And so many media outlets shy away from actually taking on these cases because of just how serious that looks to have on their balance sheets to bring to their boards. So it's, they're quite complex and nuanced issues that we're seeing. We know, as the first panel said, that claimants don't always win, but that's not even the issue. In fact, in most cases, the claimants don't win ultimately, and a large number of the cases are dropped before they reach trial. But for the media, this isn't necessarily good news, particularly if they were prohibited from reporting on the story during the case at hand. And I think we're going to hear a lot about that from some of the panelists today. Across Europe, we've seen defamation as the main law of choice, but increasingly we see privacy and data protection being used. So we really need to keep an eye on those laws. So it's not just about defamation reform, it's about looking at SLAPPs as a phenomenon and as a trend, and to create and establish the legal protections to protect journalists and other activists from all of these types of laws that can be used. So we need to be looking a little more broadly than just at defamation. We'll hear a lot more in the days ahead about how not all of these cases go to court. In fact, that it's largely bullying by legal letters. And those are not just the letters that we're so familiar with in the UK context, but we also see this across most jurisdictions in the EU and candidate countries, just how often these types of legal letters are used to silence and intimidate. So ultimately, it is that the process itself is the punishment, that this is an expensive journey down a particularly torturous legal road, and that we see that there is really insufficient protection, in particular against cross-border cases. This isn't uniquely about London. We also see a huge amount of cross-border litigation emanating out of places like Paris and Brussels. Most francophone cases that may emanate in Africa are usually taken through the Paris courts. And I think then, just to sort of round up, that we really have seen that SLAPPs really what Maria said at the beginning, are part of what could be termed as, hybrid attacks, or a really coordinated strategy of censoring journalists and silencing the messenger. So we need to understand these in the wider context. So with that in mind, we're going to turn to our panel today, and we're very lucky to have journalists from Australia, Poland, Cyprus, Slovakia, and India. And we have Steve Kinane here with us, so delighted to have Steve. And we'll begin just with a conversation with Steve first, and then we have videos from a number of our colleagues, and then we'll have a panel discussion where we can all talk through some of the big questions that have been raised. So Steve, I'm just going to start with asking you to you have a fascinating story of SLAPPs, and just really over to you from the Australian perspective.
All right. Thanks very much, Sarah, and thanks so much for the organisers for putting this on. This is such an important conversation to be having. I'm really glad that's going on. And also wanted to thank Justice for Journalists and Index on Censorship too for defending journalists who don't have the institutional protection that I do. I work for the ABC, the Australian equivalent of the BBC, and I'm published by HarperCollins, so I have access to very good lawyers. I'm very fortunate. Not all journalists do, so thanks guys for that support you give to other journalists. So my story is a kind of an interesting one. I wrote a book about the Church of Scientology, and I guess in doing so I was asking for trouble. Given their history of using battalions of lawyers and private investigators to intimidate journalists and critics of the Church of Scientology, which is a cult, and L. Ron Hubbard is a cult leader, and so you can add that to your list. Cult leaders use SLAPPs as well, and I think you could make a case that if L. Ron Hubbard did not invent the SLAPP, then he perfected it. My book is called Fair Game, The Incredible Untold Story of Scientology in Australia, and it takes its name from a policy called Fair Game that L. Ron Hubbard wrote in his mansion in East Grinstead in the English countryside of Sussex in the 1960s. And the policy, and I'm going to quote from it, says, it allows critics to be deprived of property or injured by any means by any Scientologist without any discipline of the Scientologist. They may be tricked, sued, lied to, or destroyed. So it shows you what kind of motivations that guy had. And the ultimate case of, I think, of his fair game policy was a New York journalist called Paulette Cooper, who wrote a book in 1971 called The Scandal of Scientology. And she faced the most extraordinary intimidation I think I've ever heard of any journalist. To give you an example, they moved a Scientologist into her apartment, unbeknownst to her, who spied on her and fed information back to the Church of Scientology. They leafleted her apartment block with leaflets saying that she was a prostitute and a child abuser who had venereal disease. They broke into her psychiatrist's offices and stole her psychiatric records. They framed her for a bomb threat, and this is how they did it. This is how we think they did it. They got somebody to turn up at her apartment with a clipboard with a petition on it that they thought that she was politically sympathetic to, put some stationery underneath that clipboard, got her fingerprints, and then framed her for a bomb threat to a church. They also had 19 lawsuits against her. So there we go. That's pretty good as far as SLAPPs go. Now, this kind of behaviour continued on with other journalists who dared to write about Hubbard or Scientology. Russell Miller, who was a Sunday Times journalist here in the UK, wrote a great biography of Hubbard. He got sued. John Atack, who was a former Scientologist who wrote a fantastic book called A Piece of Blue Sky, got sued multiple times, had private investigators on him. Similar rumours spread about him as Paulette Cooper copped as well. And then there was the case of Richard Behar, who was a Times journalist who in 1991 wrote a really good piece of journalism called The Thriving Cult of Greed and Power, and it exposed Scientology in Time magazine at the time, which was quite widely read across the world. Now, he then faced Time Warner faced a libel suit for $416 million. That dragged out, it went to the Supreme Court, and it was not exhausted for a decade after. And when we talk about the chilling effect, and that's something that Baroness Kennedy mentioned earlier today, that case had a massive chilling effect on anyone reporting on Scientology for decades. And in fact, I once spoke to a British journalist who worked for a big newspaper here, who told me that he went to his editor one year and said, "Oh, I'd really like to expose the Church of Scientology." And he basically said to him, "Mate, go to Northern Ireland and expose paramilitaries if you like, but we're not touching the Church of Scientology." So that gives you a kind of a sense of the impact that that case had for decades, really. So if we just go to my kind of story, I got a series of legal threats from the Church of Scientology when I was doing stories on Scientology at the ABC, and also while writing this book. And when I got responses from the lawyers when I was writing this book, because the Church of Scientology would not speak to me because they're beyond scrutiny, so they gave me statements issued through their lawyers. So I decided to put the lawyer's name and their law firm in the book, because I thought that if a law firm and lawyers are going to take money off an organisation who indulges in or is guilty of human trafficking, forcing women to have abortions, and also enslaving its followers, well, I'll put their name in the book. If you're going to take their money, I'll put your name in the book and let the public know that you're happy taking their money. So I wrote the book, I published it. I got on a plane from London to Sydney thinking, oh God, what have I let myself in for here? You know, what's going to happen when I land? Anyway, I was pretty unscathed. I thought, oh well, there was no attack groups or no probably private investigators I didn't know of, and all went pretty smoothly. 6 months later, I got a legal letter demanding that I pulp the book, make an apology, pay costs, make amendments to the book, and the legal letter came from one of the law firms that I named in my book as being Scientology lawyers. Except this time it came from a different partner in that law firm. I'll name the law firm again, Kennedy's. Obviously unrelated to Baroness Kennedy, who wouldn't be involved in anything like that. And in a bizarre twist to it all, I was not being sued by the Church of Scientology. The two people who were suing me, one was a doctor and one was a psychiatrist, a former psychiatrist I should say, because he was struck off the register for poor behaviour. And they were two people that the Scientologists hated. But both had been key figures in a small private hospital in Sydney called Chelmsford Hospital, where 24 people had died after undergoing an experimental and dangerous form of deep sleep therapy, where they'd comatose them with barbiturates and given them electric shock treatment, some of them against their will. And I wrote a chapter relating to this because, bizarrely, I wrote about the only piece of evidence I could find of where the Church of Scientology did something good, which is they put a nurse in undercover in this hospital who stole the medical records and then exposed one of the biggest cases of medical malpractice in Australian history. And to tell that story, I had to tell the backstory of deep sleep therapy and what was going on there at that hospital, the practices they were engaging in. And to do that, I relied on what we call in Australia a Royal Commission, which is like a judicial inquiry. It was done by a retired Supreme Court judge, and over 21 months he went through what happened there, and he was scathing in his assessment of these two people who are now, decades later, suing me. So frankly, I couldn't believe that they were suing me, and I just thought it was a try-on and that it would go away. But unfortunately, Australia is a paradise for both defamation lawyers but also aggrieved individuals with lots of money and hurt feelings. So I never really thought it would get to first base, and we had a court case where we tried to get it struck out for abuse of process, and one of the arguments that we argued was it was unfair and oppressive when applicants who'd waited decades to sue me for something that other people had been saying for decades about them, and then I have to prove it's true when a lot of the people from the 1960s and 70s who I would naturally call on witnesses were dead. So we'd said it was oppressive and we tried to get it thrown out. We lost that case. We then went to mediation. That went nowhere. We then had a defamation trial that went for 8 to 9 weeks, and I was cross-examined for 3 days. And to give you an understanding of how we value public interest journalism in Western democracies at the moment, the Silk who cross-examined me for 3 days got paid more to cross-examine me in those 3 days than I got paid for my book, which took me 4 years to write and research. So, finally, we won. And this happened pretty much a year ago. It was in November last year, and it was a 270-page judgment where the judge was scathing of both these characters and said I was an honest and credible witness. And I was told after that case that I was the first journalist ever to win in Australian history, both on the truth defence and qualified privilege. And what qualified privilege really means is that even if I could not prove that what I did was true, that I went the hard yards and did everything I could to accurately report what I reported. But it's not over. So the former psychiatrist Heron has died, but the GP who is mentioned once in my book has appealed. And now it's before 3 federal court judges, and it's back in the court again this week in Sydney. So the lawyers for the doctors are trying to say that some of our evidence, the defence's evidence, should not have been allowed in, the truth defence, evidence that was from that judicial inquiry that I quoted from, which I relied on both for the book but also for my defence. And if that gets up, and if they overturn the qualified privilege ruling, I may face another trial. So far it would have cost HarperCollins, I would estimate, at least £2 million to defend my book. And remember, it's now 4.5 years since the doctors, through their lawyers, first asked me to pulp that book. And by the way, when I first got that legal letter, I said to them, I'm a journalist, I take my job very seriously, and if I've made any mistakes, tell me what they are and I will correct them. They never came back with any corrections. I personally don't think I'm a victim of a SLAPP suit. I think that I'm being sued by 2 cranky old men who have access to a lot of money, who want to rewrite history on their last days on Earth. But I do think that my circumstance and that of other journalists in Australia is worth talking about, because I've published a book in a country with some of the worst defamation laws in the world that allow individuals with money to silence journalists who are acting in the public interest. Now, this case would not have gone to court in the UK. Article 10 of the European Convention on Human Rights would have ensured that it got struck out at the first threshold. And I can report that there is some improvements in Australian defamation law, where we now have a serious harm threshold in virtually all jurisdictions, which has come in the last 6 months. Because in my case, after all of that, the judge basically said, and I'm summarising here, that they didn't have reputations worth defending anyway, right? So if we have a serious harm threshold, it doesn't even get to court. And at the moment in Australia, we have an epidemic of politicians suing either journalists or individuals on social media, and this is because they have power, they have access to good lawyers, and they live in jurisdictions where applicants almost always win. So people often say to me, oh, it must be really stressful to be sued and have a case drag out for 4 years. And I have to answer, in my instance, it's more tedious and time-consuming than it is stressful, because, as I mentioned before, I have the institutional backing, in this case with this book, of HarperCollins, who've been fantastic in defending me and providing very good lawyers for me. But what I really get pissed off about is how much time it takes up. It stopped me doing stories that I want to be doing. I spent all this time on my defence. In the middle of all of this, I was doing a series exposing the gambling industry in Australia, and I had a lot of stories to tell, and I couldn't tell as many stories as I would have liked to because of the colossal waste of time of defending myself and my book. And these kind of cases do have a chilling effect. There's no doubt about that. They make publishers and they make editors think twice about taking on stories and books that cause trouble. And remember what I said before about the Time Warner case with the Church of Scientology? That had a ripple effect that lasted decades. And the waste of money is absolutely criminal. If it's at least £2 million, I just keep thinking of the victims of that hospital and their families and what they went through And they should get that money, not a bunch of defamation lawyers. So that's pretty much I have to say about my case.
Thank you, Steve.
Thanks.
And this question of time is really present in the first of our video testimonials, now from Poland. And just the level of time and resources that SLAPP cases are draining. In the first video that we're going to hear from now, Emilia from Gazeta Wyborckza, Poland's leading independent newspaper, which is facing at least 50 SLAPPs by our latest estimates, often taken by the politicians and pro-government businesses, often taken both in civil and criminal law. And it's a phenomenon that we've seen really growing, especially in authoritarian regimes in Europe. So we'll just have Emilia speak now.
Since 2015, there has been a significant increase in lawsuits and pre-litigation subpoena filed against the independent media or the journalists as compared with 2015, including lawsuits over the alleged violations of personal rights lodged by, amongst others, Jarosław Kaczyński, the head of the ruling party, state TV and state-owned companies, which are some of the biggest and wealthiest companies in Poland. Those who attack the media or activists have considerable resources at their disposal. In the case of the ruling coalition, the financial possibilities are unlimited, and let's be honest, ultimately it is a Polish taxpayer who foots the bill. Journalists, Gazeta Wyborcza and Wyborcza's publisher, Agora, have significant number of SLAPPs. The lawsuits require dedicating substantial amount of work, time and human resources to them. In these proceedings, SLAPP proceedings, the final awarded amount of the penalty is not as significant. The charges are mostly dismissed. These activities are aimed at increasing the burden placed on legal departments, defocusing them from their other cases. The cost of SLAPPs are noticeable in our case in an increase in person hours and expenses for legal services. We had to enlarge the legal team and increase their salaries due to the rise in their workload. Because of all that, it is difficult to distinguish these expenses so clearly from ordinary costs. The number of criminal cases is especially alarming in Poland. As many as 25 are pending under the Article 212 of the Criminal Code. The article has been criticized for years by journalistic bodies, the Helsinki Foundation for Human Rights, and international organizations as posing a severe threat to freedom of speech, with numerous calls for its immediate repeal. It provides for a punishment of up to 1 year in prison for slander through the mass media. Organizations defending the freedom of speech believe that, in this case, the civil law and press law provide sufficient legal protection for potential victims, and yet the criminal law is being used to silence the journalists under the Law and Justice Party rule. Many of these proceedings drag on for years, are costly and stressful, basically for everyone. Even if the defendant ends up winning the lawsuit, it is at a tremendous personal cost. More often than not, these suits result in health issues, primarily due to pressure. Just to summarize it all, SLAPPs harm not only journalists, as we all know, the paper or the publisher, they also hurt their readers. And this is something we as a publisher keep in mind and have to keep in mind for the future.
So that was from Emilia, and Emilia will be with us at the end of this for a Q&A. But I think what's really important, and we've worked a lot on Poland over the last number of years, and colleagues have been in court for a lot of these cases, and you can just see that there's this mounting pressure because of the number of cases that are taken, both civil and criminal, that form part of a strategy to really pressure the remaining independent media to both drain their resources from reporting on the corruption of the government and of pro-government businesses, and then it's these same individuals taking the cases that is just completely draining the resources of the paper. So we're going to turn next then to Cyprus. And we have Stelios Orphanides, who's an investigative journalist with the Organised Crime and Corruption Reporting Project.
Hello everybody, my name is Stelios Orphanides. I would like to tell you about my experience with the SLAPP that goes a couple of years ago. It all started when in 2017 I received a tip from a whistleblower about two Libyans One of them was the chairman of a state-owned organization in Libya during the Gaddafi era, which was constructing hospitals, schools, airports, roads, and other projects. And together with his accomplice, they set up several companies in Cyprus, in Germany, in Italy, in Switzerland, Liechtenstein, and other jurisdictions, and through them they participated in the competitions that that organization was occasionally announcing, and of course they were the winners of those competitions. Now, we started investigating this case for about 6 months, and in July 2018, we ran a story on the website of OCCRP, which explained how these Libyan nationals operated, how much money they had managed to embezzle this way, and some indications where this money went. And immediately after that, a couple of days later, we received a lawsuit from one lawyer who was offering them services at the time and before. And that lawyer sued us on the grounds that we had spread with our report injurious falsehoods about him and his law firm, and also we had attempted to deprive him of his right to exercise his profession. He was not the only plaintiff. A law firm he established several decades ago, in the 70s or in the 60s, was also a plaintiff. Also the successor law firm, which was established after the first law firm was found guilty in 2017 of bribing the Deputy Attorney General in Cyprus. And two other lawyers were also among the plaintiffs in that lawsuit. Of course, it meant for us that we had to leave our work and start preparing for this case. And of course, for them, for the plaintiffs, it was an easy thing to file a lawsuit because it's something that they do, all the time. I mean, this is their job. For us, however, it involved a significant series of obstacles. Okay, it involved a very steep learning curve on how to deal in such cases, and it also involved finding lawyers, dedicating a lot of time in preparing the documents for the trial, and of course explaining the case to our lawyers, and so on and so on. So we can say that we both have dedicated several weeks of working time just to prepare for this lawsuit. We don't know whether this lawsuit is going ever to be trialed. Okay, the first hearing was set for October next year, but in the meantime, the lawyer who sued us died 2 months ago on COVID, and while it is very likely that his colleagues at the law firm who are also plaintiffs, and the two law firms may wish to continue coming after us, it might involve further delays. And in Cyprus, since courts are very slow, it might take several years for us until we manage to bring our case to explain our case to a court and get, let's say, a ruling. If it's favorable, that's fine, but if not, we are asked to pay up to 2 million euros in compensation, which shows how disproportionate the justice system is allowing such lawsuits to go ahead against two journalists who simply reported on the facts. Thank you very much. I'm ready to take any questions we may have.
Thank you, Stelios, and we'll come to you at the end again. But I think what you can see there is, just the length of the proceedings and the amount of damages. So Stelios and his colleague are facing the possibility of having to pay 2 million euros in damages, and something he had said earlier was, that they're just trying to figure out how on earth they could actually raise that sort of money if that's indeed what it comes to, and that they've no protection before that. Something we've seen in other countries, particularly Italy, is that issue around the length of the proceedings. You have SLAPP cases there that go on for 10 years, up to 10 years. So we've seen the length and the duration of these cases is such a huge issue. We're then going to go to India. So Subir Ghosh is a journalist and researcher, and he's the author of Sue the Messenger.
Hello everyone. My name is Subir Ghosh, and I'm the lead author of this book, Sue the Messenger: How Legal Harassment by Corporates is Shackling Reportage and Undermining Democracy in India. The book was published in May 2016, and I was the lead author of the book, and the co-author was senior journalist Poranja Gotuaguta. The book had a personal context to it. It came in the backdrop of an earlier book that we had done, published in April 2014. It was called Cash Wars, Crony Capitalism and the Ambanis. There, Poranja had been the lead author, and I was the co-author along with a colleague of ours, Jyotirmoy Chaudhary. The book, without going into the context of the book itself, drew as many as 4 legal notices. 3 came from the Reliance Industries Limited, and 1 came from the spin-off group, which was the Anil Dhirubhai Ambani group. Now, what the book did was, it of course did harass us a little bit, but what happened was that the book simply disappeared out of public glare. There were very few reviews about the book, precious few, and there were no flattering reviews, there were no damning reviews. No, it was as if the book did not exist at all. The book did sell a little bit, but it was not, even though it was something very, very topical, the book was somehow missing from the public glare, as I said. Now, this kind of set us thinking, because what we knew of, there were 2 other cases, so to speak, that happened around the same time, where authors were either slapped with defamation suits, or they had to withdraw the book altogether. Now, what we realized was that just not these 2 cases, but that there were lots of others that we as journalists were kind of either privy to, or we just happened to know of for some reason or the other. And we thought that it would be not only interesting, but it would kind of be our journalistic duty to write about something that was hardly ever talked about beyond our journalistic or activist circles, which is the question of defamation suits, or to enlarge the subject to SLAPPs. Now, the first context, like I said, was our own personal backdrop. The second was that there were lots of other cases that were happening around the same time, or which had happened in the preceding few years. There was a third context to this book, and which was the India Against Corruption agitation, which had kind of peaked in late 2010 and early 2011. Now, what this agitation had done was that it had directed all public anger, all public ire towards politicians, and somehow for some reason or the other, it were always the business houses and the corporate groups which seem to be missing from the picture. But the thing is that now all the cases of corruption that had happened heavily during the second DUPA regime from 2009 to 2014 were all cases of corporate corruption, all cases of crony capitalism, and it was extremely disconcerting to see that the business houses were kind of exempt, so to speak, from that public anger. And we thought that you need to write about business houses and beyond the hagiographies that have always existed. And this provided kind of the backdrop to the book. And we thought that we should come out with a collection of stories. A collection of stories about stories. And we spoke to a lot of writers and journalists for this book, and almost all of them responded. Some did not want to be named for obvious reasons, and except for just one person, everyone had responded, and we were extremely glad, and I'm extremely thankful that they did, because otherwise this book would not have seen the light of day. So that is what this book was. It was a collection of stories about stories, because we felt that people need to be told. It is the public's right to know what happens in this country, and it is also the public's right to know that they are being deprived from their right to know through certain legal means, and those are the SLAPPs in question. And but what we consciously tried not to do was to bring out a catalog of legal cases against writers and journalists, and we had to leave out, for logistical reasons, SLAPPs against activists, especially environmental activists in this country, and that's a different canvas altogether, and a different ball game altogether, and needs probably a canvas in itself. But this is what was the backdrop to our book. That was in May 2016. 5 years have gone by, and what has happened since then is again a story in itself. Thank you.
Thank you, Sabir. And now our final testimonial is going to Slovenia. Prima's chairman, who's a journalist with Net Cenzuriano in Slovenia, and it's quite a famous case where one media outlet was subjected to at least 39 SLAPP cases, and I know it's a case that Flutura's organisation has supported them over the last number of years. So, Prima's, over to you.
Hello, thank you for inviting me. My name is Primož Cirman. I am an editor and journalist of Slovenian news outlet netcenzurirano.si. Our media is very small. We are consistent of basically 3 people, 3 colleagues that have established it, because we always wanted to work on our own. Basically, the reason why I'm here is because the same reason why everyone else is here. It's because we are currently going on an expensive journey and a potentially dangerous legal road, as Sarah has said at the beginning of this conference. We are target of 39 SLAPP lawsuits. They were filed against us by Mr. Rok Snežić. He's a Slovenian citizen tax advisor and personal friend of Mr. Janez Janša, our Prime Minister. And he is also self-proclaimed advisor, although he does not have any official title. However, he is very influential in circles close to the ruling party, and he is believed to be behind many decisions, political and regarding putting people on positions in state-owned companies. So basically, to tell our story, we published over a 3-year period, we published a series of articles regarding Mr. Snežić's business dealings and connections with Bosnia and Herzegovina. And because this is the country where almost €500,000 worth loan to Slovenian Democratic Party came in December 2017. That was half amount before general election. €500,000 is a lot of money for any Slovenian political party. To put it in perspective, the average cost of a political campaign in general election in Slovenia is around €200,000, maybe €300,000. So basically, with that money, you can buy the election. And after we published articles, and after Janša came to power in March 2000, in March last year, lawsuits started going in, and we believe it's abundantly clear that this number and nature of these defamation lawsuits are not aimed at achieving justice, but to silence our outlet, because it means that this fight is very time-consuming. Legal battles are costly, and we know that he's trying to drain us financially and discourage us from further reporting. So to put it in perspective, 39 lawsuits, that means 13 lawsuits for each of our journalists, because they are filed over a penalty law. Of course, that these 13 lawsuits for each of us are basically the same. They're very similar. They are. If you compare these 13 documents, if you compare these 39 documents, you can see that they go over the same pattern. One sentence is put out as a defamation, and there is a 2-page, maybe 3-page claim that the reputation of Snežić was seriously disturbed. However, you also have to know that Mr. Snežić was previously convicted for tax evasion, and his reputation was damaged before. And of course, now we face this. We face these charges, and of course, we wanted to court to merge these 39 lawsuits into one, because they all basically they based on the same claim. However, we did not have any response now from the court. Au contraire, Mr. Snežić, the only news now is that Mr. Snežić wants to avoid paying a court tax, because in Slovenia, if you file a court lawsuit, you have to pay a tax. And for 39 lawsuits, the tax is €5,000. Let me repeat again. The article was about a €500,000 lawsuit for money that came from Bosnia and Herzegovina through some unknown proxy citizen there to largest Slovenian political party. And he does not have €5,000, although we know that he is basically driving very expensive cars. He lives very luxury lifestyle, and he is said to be a shady owner or hidden owner of at least 10 to 15 real estate projects. We knew that this would come straight after the new government came. As soon Mr. Janša came to power, Snežić started to publicly speak about his intention to file lawsuits, and his claims were also published in various media that were co-owned by our ruling party or key members or proxies that are close to Hungarian Prime Minister Viktor Orban. You have to know that media that are close to ruling Slovenian Democratic Party are basically owned by proxies of Mr. Orban. So basically, Snežić not only filed 39 lawsuits, that these lawsuits were basically had also a smear campaign with various defamations against us. They were very these articles were like presenting us as the lowest human beings. They were full of chauvinist, sexist, and other implications. They claim that we are some agents of deep state that are trying to virtually do damage to this political party. And of course, now the pressure is increasing while we wait on the court, which is, as I said before, mentally and financially draining, because, let me repeat again, we are an outlet consisting of only 3 people. the pressure is rising. In 5 months, there will be election in Slovenia, and Slovenian Democratic Party has stepped out the way of pressuring Slovenian journalists. You're probably aware of the story of Slovenian press agency, but I can tell you from our example that pressure is rising, and various state organs have been called into action. We are having constantly visitors from tax inspectors, from work inspectors. They're trying basically to block our only bank account to which we get some donations, we get some ad revenues, and we do media business to it. They basically do not hide it anymore that they want to shut down our media and close it down. So therefore, as it seemed that SLAPPs were the worst thing that happened to us, that was the picture in 2020. Now we see that SLAPPs were basically an introduction, a showcase of what we can do to you. And we are very afraid that it's very debatable how long that we could basically hold on, because it means enormous pressure on not only on business-wise level but on personal level against all of us. So we know that we talk about SLAPPs today, and I hope that we will talk also about some systemic solution to this problem, which is crying for solutions on EU level. Thank you.
Thank you, Primoz. So I just wanted to really highlight, what Primoz was saying at the end there is so reminiscent of what Maria began the conference with, that these sort of SLAPPs as part of this hybrid attack on journalists, on civil society watchdogs, and how, I have to say, just this sense of almost PTSD listening to this, because of what we saw happened in Malta. Daphne was subject to over 40 of these cases. The fact that these cases then are used as part of a strategy, also through these smear campaigns, through labeling the media as scum, you dehumanize, you denigrate, and then that paves the way both to financially cripple journalists. I think this is another issue that we've seen. Like when Daphne was killed, she was actually going to the bank because her bank accounts had been frozen under a garnish order because of a case that the Minister of the Economy was taking against her. So she was literally going to the bank when she was murdered to deal with the SLAPP issue. And so when we hear these same testimonies from places like Slovenia, I think we need to be very cognizant of how these fit within very frightening tactics that are used against public watchdogs, and why it's so important at this point that we're able and we find ways to head off these types of lawsuits, because they're so serious. So I think we now have all of our panelists, I hope, with us. Wow, brilliant. And we're really lucky to have such a wide array of testimonials from such an array of jurisdictions. And I wonder if we could really begin, Steve, I think this might be, just to start with you. What's interesting about the Australian context is, as you said, there's actually, the law is largely bad, but there are some good parts. So I think Australia, unfortunately, of the countries here, it might be the only country where we have a little bit of good practice. So could you talk just maybe a little about how we've seen defamation reform working, and maybe then how we can think from the other countries, like what would help in these contexts?
Well, if I can talk specifically about SLAPPs and how that relates to Australian defamation law, and it was something that was brought up in a question on the panel that Nick was chairing. SLAPPs aren't a massive problem in Australia. I think it's partly because we don't have journalists writing about the same kind of autocrats and oligarchs that are a focus in Europe at the moment. But in Australian history, there was more environmental activists and Green MPs who were getting hit with SLAPP writs, and there was a famous case in the early 2000s involving a wood chipping company in Tasmania, and the group of people who were sued in this SLAPP writ became known as the Guns 20, because there were 20 individuals and organisations who were sued, and it was a SLAPP writ, there was no doubt about it. But what happened is in 2006 the law changed in Australia around companies being able to sue. So companies with over 10 employees could no longer sue for defamation, and that shut down that aspect of SLAPP writs. And I think that's really, really important. And so if Catherine Belton's case has been mentioned today, and she's being sued by this state-owned company Rosneft in Russia, as well as 4 oligarchs. I think 3 of the oligarchs have dropped their cases against her. But in Australia, Rosneft could not sue because they're a company of over 10 people. And I think that helps when it comes to SLAPP writs.
And it's I think it's something really interesting for us to be bearing in mind as we're looking at model legislation here. Over then to the panelists. Emilia, I wonder if I could start with you. I think something that's really not unique to Poland, but interesting is the way both the civil and the criminal law are used as a strategy against papers like yours. And I wonder if you could speak to that a little bit.
Yeah, thank you, Sarah. So thank everyone for your remarks and for doing this. And this conference is really important. And as Sarah said, we do have both civil and criminal cases here in Poland. Still, it's mostly civil cases for violation of personal rights, because defamation in Poland is a criminal offense. So that's a bit different. And we do have criminal cases. And this is actually an article of choice for Peace Party leader, so Jarosław Kaczyński, for our Minister of Justice, Zbigniew Ziobro, who is actually also a prosecutor, general prosecutor in Poland. And it's also used quite often by the newly appointed judges that are criticized for the way they've been appointed. So the leading party actually changed the appointment system for judges. So this, we have SLAPPs, and then they land in courts when we know that there are new judges that have been appointed by the leading party. So this all becomes quite problematic and quite big. And so criminal law is being used in a way that's quite not unique in Poland, because we think that that's really often, it's not the biggest amount of cases. But again, criminal law is used in a way that it basically has to be private notice to a prosecutor to start such action. But then there's one instance when actually a prosecutor can lodge a case himself when there's a social interest in the case. And we know that when the Minister of Justice is also Prosecutor General, and he's basically the president of the prosecution's office, we know that prosecutors are actually lodging such actions themselves. And there's one prosecutor's office in one of the cities in Poland that's famous for lodging such actions. So this is quite unnerving and something that we're seeing more and more. We do not have many criminal cases. As Agora, we mostly have civil cases, and they are mostly targeted not at single journalists, but at Agora as a publisher. So this is what we are seeing more. And it actually, we are speaking as Agora, but we don't know what it looks like at the local level, because journalists are quite afraid to say what they're facing. And we think that there's more criminal cases than the civil ones, because it has a punishable offense for up to 1 year in prison. It's more serious than civil law, as well now.
Thanks, Emilia. And I think a big part of the advocacy that we're doing as well is, while we see that there are certain steps that the European Commission can take as it relates to civil law, and we're really pushing for that SLAPP reform, there must be concurrent decriminalisation of defamation, because that remains such a weapon which journalists are really silenced with throughout Europe. And there's still a huge number of jurisdictions that have criminal defamation. Stelios, I wonder, just coming to you, your case is fascinating on so many levels. The actors it involves, obviously, the amount that you're facing in damages, which is really huge if you were to lose. And I wanted to ask, in certain jurisdictions, in Poland, for example, the damages aren't that high. It's that there are so many of these cases. But in Cyprus, that's different. And I wonder if you could speak a little bit to this issue where you have uncapped damages, what that means for journalists like you and your livelihood and your investigations.
Yes, hi everybody. Thank you for having me. Yes, I have to say that there is no upper ceiling to lawsuits. I had to double check that following our previous conversation or email exchange, and it is up to the claimant to demand as much as he or she believes that their reputation is worth. And it is up to the judge to decide whether, let's say, if there was indeed let's say some defamation in a report, that indeed worth as much as the claimant's demand. So there are many ifs, so to say, but it's the same thing as with every other case that has been presented. It's a nightmare. I mean, just having to think about what's going to happen if you lose, while you have to concentrate, you have to focus all your efforts on not losing. And of course, you always have to expect that in countries that have some struggling democratic institutions, to put it mildly, like in Cyprus, like in Poland, and so on, it is very often that you have judges who simply rule not necessarily based on the facts, but on other considerations.
We'll be closely following the developments in your case. Then turning to Subir, to the Indian context. Subir, I wonder if you could talk a little bit more, you mentioned that you feel like, corporations have really got away with, not being held up to the same level of scrutiny as maybe politicians. I wonder if you could talk just to the broader context of SLAPPs against journalists in India, and maybe if I could come back to the point that you made that you're not even going to talk about environmental activists because that's its whole other issue. I wonder if you could maybe just elaborate on that point a little so that we can understand why environmental defenders face particular and perhaps separate threats.
Yeah, thank you, Sarah, for having me here. And you actually have a range of questions there. But I'll start with the environmental aspect. You see, when this particular government led by the Bharatiya Janata Party came into power in May 2014, even they came to power on two planks. One was the issue of Hindutva, and the other one was the question of so-called development. And from what I understood, development essentially meant depredation of the environment, and that has turned out to be true over the last 6-7 years. That is one thing. But the thing, I will probably need to backtrack a bit. Say, if I could just take off from one of what I mentioned about a book earlier. See, and what Maria said in her opening remarks, that you don't really need to kill journalists anymore. The SLAPP suits are enough. But India, it has gone a step ahead, in the sense that you don't even need to file SLAPP suits. You don't need to take cases to court. Just a few legal notices would be enough, and that is what we experienced as well. We got as many as 4 legal notices for our book, and the third 3 from the elder Ambani brother, and the last of the legal notices said that you haven't responded to our earlier notices, so please give us 100 crores. That would come to 1 billion rupees. I mean, that is essentially meant to psych you out. And that actually works. It works for you and it works for others as well. No, there were speakers, colleagues earlier who spoke about the chilling effect, and this chilling effect has more or less continued for the last 5-6 years, since the book was published. That is what I feel. What has happened is that you have a very authoritarian government. You also have a climate of fear. What happens in this backdrop is that you don't have the mind space. You don't have the you are always apprehensive, to do some story that is going to kind of push the frontier or going to push the envelope. So the chilling effect has worked in the sense that there are not far too many stories that come out in the papers regularly. I mean, they probably you have 3-4 stories, 3-4 good stories a month. My hunch is that, if there were no such chilling effect, if there were no such climate of fear, then we would probably have 30, 40, 50 stories every month, because that is something that that you as a journalist are aware of, but but you also know that nobody is writing about it because nobody wants to do those stories. Why would you want to do such stories? Because because the process itself is the punishment. Apart from the fact that you get a legal notice for astronomical sum, somebody got a legal notice for 10,000 crores. That would be 100 billion. Those are astronomical figures. I don't even know how they come up with these numbers. Whether they come with these numbers themselves, or they know, or their legal advisors throw up these numbers. But the point is that the numbers work. Numbers work in the sense that it psychs out everyone. So before you do a story, you would think twice. Earlier, if you're doing a controversial story, you would give it due diligence. You would think you would go through the numbers, you would go through the names over and over again. But now you have to think 4-5 times, and finally you decide that self-censorship is probably the best way ahead. That's as far as our journalistic work is concerned, and also lots of writers too who do the same kind of work. Now, coming back to the question of environmental activists, see, most of the corruption-related stories somehow related to environment, mostly plundering of natural resources, be it extraction of natural resources. Let's put it that way. Be it coal mining, be it plundering of forests, mostly these two, and this government has been trying to dilute all the environmental laws. Every day we know of some law or the other being thrown to the winds, which the India's corruption story is, most of it is an environmental story, and environmental activists have also fared the brunt. We decided to leave our environmental activists because, like I said, that will need a canvas in itself, and among environmental activists, those who in case of environmental activists, it is a better idea for a lot of people to pump them off, and that is the number of environmental activists who have been working on the issue of sand mining has been extremely high. I don't remember the numbers, but it's quite high. Why is it high? Because there's a chain out there. The chain starts from the riverbed. So you have the people who do those sand mining. Then the next in the chain probably comes the real estate mafia. Then you have the construction mafia, and then you have lots of other people who gain from the entire chain. So the question of development, the question of real estate boom is also a question of environmental corruption, environmental degradation. So that's one of the reasons why environmental activists, especially the sand mine people who have been working on sand mining issues, have been targeted, and targeted quite brutally. I hope I answered your question, because we had quite a range out there.
And we'll just turn to Primoz now. So, Primoz, you mentioned at the end that now is the moment for reform. How do you see that reform at the EU level, and even, coming back to what Steve was talking about, some of the provisions they have in Australia, how do you think that could improve the situation for journalists like you in Slovenia, particularly, as you say, you're heading into an election and you're expecting more of the same? Oh, we can't hear you. Primoz, are you on mute?
Okay, that's better. That's better.
There you are, yeah.
The solution is, in my opinion, Swedish model. In Sweden, you cannot file SLAPP lawsuits against journalists or activists because a court can or is even obliged to reject them. What the criteria is that, for instance, if there's plenty of lawsuits based on one claim, are they filed by the same person, or the public interest in the matter of the lawsuits is so high, that means that court can reject lawsuits. Of course, Swedish journalists have problems because now there's a case of businessman that filed a lawsuit against one Swedish media in London and Monaco, but they can't file it in Sweden. So basically, even if Slovenia, which by the way has a very strong defamation law, and which is the reason used to be one of the reasons why even in better times our position in media freedom index was not as high as we wanted to be. So that means that even if our country introduces these preventions, that we can still be, in this case, for instance, charged in other countries, because the guy that we're talking about is in charge of 20 million euros worth money laundering scheme, investigated the police, and operates in at least 7 European countries. So basically, this would not help in our case, but it would help in a case on a EU level. That means if the directive of EU would basically recognize that SLAPPs are harmful for some pillars of European democracy, then these solutions would have to be introduced into national laws. And if you get in, so basically, the maneuver space of these people for these methods would very, very much shrink. Just one more thing regarding our case. Mr. Ghosh described the chilling effect of the SLAPPs. A chilling effect is not only on us, on our personalities, on our media. Chilling effect is virtually a message to all the journalists, because in our case we see that although the police investigating the case in several countries, several other institutions that also some high officials in Bosnia and Herzegovina and Serbian part are involved in this case, we see that Snežić managed to kill the story in other media. No other media in Slovenia is now following this story because they see what happens to us. And that is basically, this chilling effect is the real danger and a proof that the pillars of European democracy are threatened by these practices. And also in other steps, the EU should have a systemic approach to countries into supervising them. How are they introducing this legislation into national laws? But I also think that some solutions from Australia are very useful for EU. But I think that EU needs a basically stronger statement, especially because you see that our panel now comes from the countries that are officially democratic. They do not, for instance, they are not Russia, not Turkey. Some rule of law should still be there. And we see that these elements are now spreading like a disease, like COVID, to the countries that, for instance, 5 or 10 years ago would not have with any such dealings.
Thank you, Primoz. And I think what you're saying is so true, that we see both the those in power and their lawyers learning tactics from one another, and it is indeed spreading. And I think, I wonder, Steve, if we could come back to this question of the role of lawyers in SLAPPs. And I suppose something I wonder sometimes about is, you know, here in the UK we have cab rank rule, law firms taking these cases, you know, will obviously rely on the argument that everyone has the right to a defence.
Yep.
You know, but we're very worried when it comes to sort of legal ethics and standards in the way in which lawyers are involved in designing these cases. I wonder if you could comment on some of the...
Well, I think you said a key thing there, which is everyone has a right to defence, and that is, to me, what the cab rank principle is about. And that is, and this is a principle that goes back hundreds of years, and Thomas Erskine, the lawyer for Thomas Paine in the famous case in the 1790s, when he published The Rights of Man, made an impassioned plea about the right for lawyers to represent individuals no matter how odious they were, or no matter how odious the public thought they were. And this is a really key principle. But I don't think it applies in these kind of situations. The principle here is access to justice. Everyone has a right to access of justice. These cab rank rules are not being applied about the access to justice. In fact, they're undermining justice. And what they're doing is undermining freedom of expression, freedom of the press, and democratic values. And there are already exemptions to the cab rank rule. For example, a barrister does not have to take a case in a foreign jurisdiction under the cab rank rule. And I think they should have exemptions when it comes to these kind of vexatious litigants who are silencing journalism and public interest journalism. And look, if we want to make it about cab ranks, if I'm a London cabbie and I'm in Soho on a Saturday night and it's 2 a.m. and I see some drunk Neanderthal who I'm worried about vomiting in my cab, I don't have to take him. So I think just as he doesn't have to have vomit in his cab, I think that law firms and barristers don't have to have dirty money washing through their chambers and their law firms. And I think they should be able to say no. And if they feel like they can't say no, just tell them you're playing golf and you're not available. I just think I think people need to take a moral position on this kind of thing. You know, decisions were made about not trading with South Africa during apartheid. Why can't you make decisions about not taking money? I mean, this is an age of undisclosed wealth orders, Magnitsky Acts, modern slavery acts, where we demand transparency when it comes to contracts and how money was got and how was it ill-gotten or not. Why can't that apply to legal cases and law firms and barristers accepting dirty money?
Thank you, Steve. I think that is a very impassioned and important note. Suze, how are we doing for time? We're okay? I wonder, just, we have 1 minute left, so I think maybe I'll just say a huge thank you with that to the audience, to the brilliant panellists from so many jurisdictions, and your testimonies have been so important to illustrating the impact of SLAPPs in such a wide array, be it cranky doctors, Scientologists, corrupt politicians, oligarchs, corporations. You know, we see that while the tactics and the subject at hand is so different, the impact on all of you is really quite similar. And so hopefully with the solutions that we're now looking towards bringing in various jurisdictions, we can begin some redress and to fight back. So a huge thank you to our panellists, and of course to Justice for Journalists and the Foreign Policy Centre for having us. Thanks.